So, hello everybody. My name's Matthew Hunt, head of the Not-for-Profits Programme and Secondary Specialisation at LawWorks. And for today's free talks, we're going to be talking about incorporating charities. And I'm very pleased to be joined by Sylvie Nunn, who is a partner in the Charities and Social Economy team at Wrigleys Solicitors, to discuss this topical issue. I'm also very pleased that we've managed to record this during lockdown. So you'll see that we're all in completely different rooms. We've planned this so that shouldn't detract from the quality of the talk and has actually made it slightly more interesting for us to get involved in. So on that note, I'd like to begin with a question, which is, Sylvie, when we talk about incorporating a charity, what do we mean and why would we do it?
So firstly, hello everybody. Charities come in a lot of different types of structure. And some are what we call unincorporated and others are what we call incorporated structures. So when a charity is unincorporated, the charity doesn't have its own, what we call legal personality. So it can't hold assets in its own name, it can't be sued, and so on. It exists through its trustees generally. And so they would hold assets, they would employ, they would sort of do all the other things that the charity needs to do. And including the holding of assets, which can be quite complicated then when you have changes of trustee, trying to make sure that assets pass in the right way. And of course, there's potentially a personal risk because they're acting personally, and it's the charity doesn't exist as a thing. If you want to sue the charity, you sue the individuals. And usually you'd sue the charity trustees. In some cases, when the charity is an unincorporated association, the members might be at risk as well. So some charities don't view that as a particular issue, but for those who do, they might look to change their status into an incorporated structure. And so that would mean setting up a new structure and transferring assets and activities and so on.
Okay, so what do you mean by an unincorporated charity then?
So an unincorporated charity would typically, in the charity context, be either a trust, a charitable trust, or an unincorporated association. So sometimes recognising what you've got could be a challenge. Most people know, but sometimes people aren't sure, and that's not surprising because the structures are quite complicated. So generally, if your charity is governed by a trust deed or sometimes a charity commission scheme, you're probably a charitable trust. And if you are governed by a constitution with a set of rules that's got some sort of committee and membership structure, then probably you're an unincorporated association. And then you have to look at sort of quite how that's established and what it means in legal terms. But it's usually a contract between the members and then some sort of trust element for holding the assets of the charity.
Okay.
Incorporated charities will include things like charitable companies, charitable incorporated organisations, or what we call CIOs, and some community benefit societies as well.
Okay, and so how do you change one into the other? How do you incorporate an unincorporated charity?
Well, sadly, a lot of people come to us and say, well, can we just have a constitution for an incorporated charity? But you can't wave a magic wand and get that. So what happens is you've got to set up a whole new charity, which is the incorporated charity, and then transfer assets and activities across to it. And then you have to decide what you're going to do with the old one. Okay,
and how easy is that to do? I can imagine there might be complications.
Yeah, it really depends on a number of things. It depends on the structure. It depends on the assets and activities and the contractual relationships and so on. So because of that, it's really important to do what we call due diligence. So to check what the issues might be, because that might affect A, whether you do it, and B, how you do it. So if the unincorporated association is really, if the unincorporated charity, sorry, is really simple, like a trust, and it's just got a bit of money in the bank account, it's got no employees, it's got no contracts, nothing that could trigger any sort of liability in any way, then it can be really quite straightforward. You just set up the new charity, and then you pass a resolution and transfer the assets across. It gets slightly more complicated if you want to give the trustees of the old charity some sort of indemnity, and we can talk about that because sometimes that requires Charity Commission consent. You also need to think about whether you keep the old charity or whether you want to wind it up, and that often these days depends on whether you're likely to get legacies into the old charity as well. But if the more complicated the assets and the trust structure and so on, the harder it can be to transfer, and the more you're likely to need a little bit of help to make sure that you actually transfer what you think you're transferring.
Okay. And you mentioned at the beginning doing checks before incorporating, a sort of due diligence. What sort of things should you be checking for? So,
I mean, the first thing will be whether you've got the power to make the transfer to the new charity. So you're looking at restrictions in the Constitution. You need to think about sort of purposes and so on. Another common thing that can be problematic is whether you've got existing contracts and grants in place, because a lot of grant agreements have a little clause that you would never notice when you're looking at them and signing up to them, which is that you can't assign the benefit of the grant. You can't transfer it to another charity, for example.
Okay.
And there can be clawback provisions. So you might need to speak to the grant makers to explain what you're doing. It's a very standard thing to do, but it's just one thing to spot and know that you've got to deal with. Pensions are a massive issue. So if you have a pension scheme that is generally a sort of defined benefit or something like a defined benefit pension scheme, so things like final salary pension schemes, then you have to be very careful, because the transfer could be a trigger event to trigger a debt. So if you've got a debt within the unincorporated charity, that might be a very good reason to try and incorporate, but it can also be really problematic in terms of just needing that extra support to get to not trigger the debt, or if you're going to trigger it, to have everything in place that you need to, so that you don't actually have to pay the amounts. Equally, in terms of property ownership by charities can be quite complicated, especially with older charities. So sometimes you can't transfer, or there's some sort of, especially with leasehold, you might need someone's consent, and so on. So it's really important that in the due diligence that kind of thing comes out, because if you need to have conversations with people, you need to have it early on. Equally, there are different types of funds that might have restrictions. So you might have special sub-trusts, you might have restricted funds because donations have been given to you in a particular way. You might also have employment claims or other disputes that are pending, where you might have a right to something and you need to make sure you can transfer it across, or somebody might be going against the old trustee, so you need to make sure that you know that and you work out how you're going to deal with it in the new charity, and the timing and so on. So and the other thing is, you just need to check the tax position both. Sometimes, especially if you've got more complicated activities, it can affect the structure of what you do potentially, and you might have to deal with things like trading subsidiaries and so on. So what's really important is not to be put off by any of these things, but just to spot them.
Yes, no, it sounds complicated, but completely doable. And
yeah,
what should a charity check in its governing document?
So the first thing to check, charity trustees will all know that they've got a duty to further the objects of the charity and not something else. So you need to make sure that the objects clause of your old charity are compatible with those of the new one. So if you are using it as an opportunity to change the objects, you might not be able to make the transfer then without taking a few further steps. I mean, it might involve the Charity Commission. Again, not a problem, but you just need to know about that. You also need to make sure you've got the necessary power to do what you want to do. And so some charities have got fairly straightforward assets, and there is a power to merge or a power to incorporate and so on, so that's great. Older charitable instruments can be more interesting, and some unincorporated associations are very interesting. So you just need to make sure that you've got the power to do what you want to do, and if you're not sure, then check. And then the way assets are held within a charity, especially a trust, can vary. So you can have some assets that could transfer across fine, and some that are held on some restricted or special trust that say, for example, you can't spend the capital, you can only spend the income and so on, which we call sort of colloquially permanent endowment. And so if you have those, you can't just transfer it to an incorporated charity. It's going to have to hold it in the trust capacity in some way. So that might affect what it is that you're doing. So you need to check for that.
Okay.
So, yeah. And there's help available. You know, you can change the objects if you need to match it. You can get, it's usually a regulated alteration depending on what your constitution says, regulated by the constitution under the current law anyway. For small unincorporated charities, there are bits of legislation in the Charities Act 2011 which can help you deal with some of the things if you find that there's a bit of a bar or prohibition. So there's a power to change objects, there's power to add powers, and so on. You just have to follow the rules very carefully, and probably if you're getting into that, you might want to think about taking advice. And then I suppose just finally, companies, if you set up a charitable company, have rules about substantial property transactions. So you need to check what you're transferring and whether you might need some sort of consent from the Charity Commission as well. So the consent that would normally be a consent for members of the company, like shareholders, in the case of a charity, it's the Charity Commission that would also need to consent to that.
Right. And is there anything about membership charities? I ask, given that LawWorks is a membership charity, so I'm curious about this point.
Yeah, it's hopefully it's an incorporated membership charity. Unincorporated membership charities can be lots of fun. Most usually when there's membership structure, approval of the members will be needed, and that'll be within the constitution. And it might well be that you also need to get the members to change the constitution in some way. So you need to have a look at who the members are and what the rules say. Most charities know who their members are. Quite a lot of them don't. You know, they know perhaps who the original members were, but the records, you know, were perhaps you know, burnt when the treasurer died and his wife thought they looked a bit confidential, and so on. So if you're not sure who the members are, then you can go to the Charity Commission and ask them to sort of decide who the charity's members are, and you know, sometimes they will help in that way, and sometimes they'll direct you to another way which might get you to the same place. So.
Sure. And what do you mean by members? Is there a definition for this purpose?
So members, it's generally where there's a body of people who are distinct from the charity trustees. So it would mean that that body of people, it can be a little bit difficult to work out what you've got in some unincorporated associations, because sometimes they're drafted by people who have a sort of, you know, here are some members, here are the charity trustees, dead easy. And sometimes with some older clubs or some older charities, there's a whole sort of different set of different people with different rights. And so you have to work through and try and work out who you think the people are who need to give the relevant consents in these circumstances. Okay,
great. And so far it sounds like we can incorporate a charity. If we can, what comes next? What's the next stage?
So once you've decided that you want to, and you can, or if you can't, then you know what you're going to do about it in order to achieve the transfer, then you need to choose an incorporated structure. So are you going to incorporate as a community benefit society, a charitable one? Are you going to incorporate as a charitable company, a CIO? So once you've made that choice, and there are, you know, different the sort of guidance available on the relative merits of the different ones, then you have to agree a governing document for it. And if it's a charitable company, you then incorporated a company's house once you've agreed the constitution. If it's a CIO, you don't have to incorporate it at company's house because the incorporation happens at the Charity Commission. So in both cases there, you would register it with the Charity Commission. If it's a community benefit society, it's dealt with slightly separately, and it's probably worth looking at the rules for that, because you wouldn't have to register it with the Charity Commission at the moment. It's an exempt charity. So I think generally people will go for a CIO these days, and sometimes a charitable company. Once you've then incorporated it, if it needs incorporating, you register it with the Charity Commission, and once that's done, you would register it with HMRC to get the tax reliefs, that, you know, gift aid and so on. And once you've got, certainly once you've got the registration of the Charity Commission done, then you would transfer the assets and activities. So you would typically not do it before then.
Right, so that comes last.
Yeah.
And how is that done, and how easy is it to do?
It depends on the assets.
Sure.
I think so. Some, you know, usually what you would have is a transfer agreement that would deal with the transfer. Sometimes you'd have separate documentation for the property, and it depends on how the property's held and so on as well. So it's if you've got more complicated assets than just cash, you probably want to take some form of advice in relation to the specific assets you've got and so on. So bank accounts are what sound like the easiest thing in the world to transfer, and you would just, you know, either open a new bank account, or some banks will actually let you keep the same bank account for both. But I think it's fair to say that it varies hugely, and that opening a new bank account for a charity is in no way as simple as one might think it could be. If it's property, then you need to comply with the Charities Act provisions in relation to the disposals of property. So you need to follow the processes in Section 117 of the Charities Act 2011, which, if your objects are the same, would probably not apply. But if you've changed the objects in some way, you might need to look at. You also need to look at whether it's on some sort of trust, in which case it might be that you need the Charity Commission to vest the property in the new charity as well.
Right.
So I think the other thing I was going to say is in relation to property, and property is a very complex matter, so it's quite difficult to sort of summarise it all quite quickly. But if you've got leasehold property, then you're likely to need landlord's consent unless that was envisaged at the outset. So it's always worth, in the due diligence that we talked about earlier, trying to spot how you're going to have to transfer it, and what consents you're going to need, and what support you're going to need right at the beginning of the job, because it can take a little while to get to the stage where you can then do it. Some of these interventions can take several months. So you probably don't want to start thinking about that once you've got the new charity set up and registered. You want to think about it at the beginning and be lining it up.
Right, of course. And will there be any sort of restrictions relevant?
Yeah, so again, this is where the due diligence comes in. So if you're holding things on a particular type of trust, you're probably going to need the new charity to hold as trustee, unless you can get those trusts lifted in some way, which would generally involve the Charity Commission. That there are some types of land in particular where if the land was given to a charity and it was subject to what we call a reverter, then if it ceases to be occupied for the original purposes, then it can revert back to the person who had it originally. And there is some legislation to help with that, but that is something that often applies for Church of England land, for example. So you do have to be a little bit careful.
Right.
It might also be that depending on what your charity does, it's registered with some organisation. So if it's a social landlord, for example, or a care charity, and so you might need to look at the lining up of any consents and so on there, and it might be that a new body needs to be transferred, needs to be registered with whoever that body was as well.
Right, okay. And you mentioned legacies. Could you tell us a bit more about that, please? Yeah,
so some charities receive legacies and some don't. If your charity does, then what you don't want to do is to do something that would mean that you'd lose legacies because you've incorporated. And some wills will say that if you give to charity, the donor gives to charity A, and if they cease to exist, then it goes to the nephew, or it goes to another charity or something like that. So the Charities Act 2006 tried to remedy this by creating a thing called the Register of Mergers, where if you register the merger on the Register of Mergers, it should save the legacy. So it takes effect as if it had been given to the new incorporated charity. Right. Unfortunately, the wording didn't quite work in the legislation. So it saves some charities, but not all. Some legacies, but not all. And if and so you have to be a little bit careful. Now, there is some legislation going through Parliament at the moment to correct that. However, a combination of Brexit and all the COVID-19 virus legislation has meant that Parliament's been rather busy to sort out some little technicality of charity law that we've all been waiting for years. We're really excited about it. So who knows when that will be sorted out. So in the meantime, you need to decide whether you want to take that risk. You don't get legacies, so you just register on the register of mergers and wind up the old charity, or whether you decide to keep the old charity as a shell to receive legacies and wait for the legislation to sort itself out and then get rid of it potentially instead. So if you're keeping it, you need to work out who its trustees are going to be, how that's going to be structured and so on. And it can be sort of easier to try and get the new charity appointed as the trustee of it, and then just sit there quietly dormant and link the two charities for the purposes of reporting and so on.
Okay, that makes sense. And you also mentioned indemnities. Could I ask for more information on that?
Yeah, so some trustees are quite happy just to transfer the assets and activities across to the new charity and not worry about it. And that would probably be the case if you're, for example, if you're just giving grants out, you've got a pot of money, you're giving grants, the risks are really low. But if you've been undertaking activities where the charity might get sued or might get sued further down the line, then probably as a trustee, you'll want some form of indemnity from the new charity because they'll have all the assets. So you might get a claim against you as an individual, but you won't have control of the assets anymore.
Mm.
So that it's quite standard to have in the transfer agreement that there be some form of indemnity. There's a limit to the indemnity that the new charity can give. It can't give an indemnity normally that would exceed the value of the assets. So you have to look at the wording of that quite carefully. But the other problem is that when you're just doing a straight incorporation, chances are trustees of the old charity will be the same people as the trustees of the new charity. And so they're effectively indemnifying themselves. And anyone who's thought about conflicts of interest and so on will know that that's slightly problematic. So in that case, in order to give the indemnity, you would apply to the Charity Commission for a Section 105 order, which is basically an order that says you can give this indemnity. And the Commission will say they'll want to know that the assets being transferred will exceed the liabilities and that the indemnity is capped to the value of the assets. There's some discussion at the moment about the wording of the orders that you get from the Charity Commission, and through the Charity Law Association, a number of people are sort of trying to work on that and what it says, particularly if what you're transferring includes pension liabilities where the assets and potential liabilities could exceed the assets. So if you've got to the situation where you're getting indemnities, I probably would get advice in dealing with the request for the Charity Commission order to make sure it covers what you need it to cover. Right,
okay. Well, that's been really helpful. But before we sort of finish off with thanks, could I just ask you to summarise the sort of key points for charities in considering or preparing for incorporation?
Sure. I think the first one is making sure you really understand your charity, and I say that with love. I was a charity trustee when I was at university. I didn't know I was a charity trustee, and I'm not sure we'd ever seen the Constitution. So what I would say is what we find in practice is a lot of people think they know what the structure of their charity is and what the governing document is, but it isn't always. So make sure you do know your charity. And doing it yourself can be risky if you don't, or if you don't do the due diligence and get the right sort of understanding of the charity from that. So, we have seen cases where, for example, the pensions liability hasn't transferred across to the new charity and so on, or there's been a major clawback of a grant, but there was no money to claw back from, and no indemnity and so on. So making sure you understand your charity is really important. And if the structure or activities are complicated, then take legal advice and take it from a specialist charity lawyer. There's a lot of people who are sort of members of the Charity Law Association, for example. There are some specialist charity firms. There are some firms that have specialist charity practitioners within them. I just can't recommend it enough, because you could save yourself a lot of trouble further down the line. And then finally, there's some good Charity Commission guidance out there. So I would say read the Charity Commission guidance if you can bear it. If you can't bear it, then I really would get to proper sort of legal advice and get them to tell you what the guidance says. But make sure you're informed. I think that's the key thing, really.
Yeah, absolutely. Okay, well, thank you very much for your time. Thank you for your expert advice and for some expert negotiation of delivering this via lockdown as well. I found it sort of informative, detailed, but also accessible. and I'm sure everybody watching or listening to this will as well. So thank you very much from LawWorks to you, Sylvie. And also I'd like to thank my colleague Debjani Biswas-Hawkes, who put this together twice, given that we originally arranged to have it before lockdown, and arranged the slides and negotiated through them so seamlessly as we were having a conversation. So that's it from LawWorks and from Wrigleys Solicitors. So thank you for watching and listening.
Well, thank you very much for listening from me, and good luck with your incorporation if you're planning on doing it. And don't be put off from incorporating by some of the complexity. You can get around most things, you just need the right advice.